The chair recognizes the gentleman from North Carolina, Mr. Watt, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director Mueller, for your service over the years. I think you've raised the standard very high, and I appreciate that. I want to follow up on in a response that you made to a question that Mr. Conyers gave. You used the phrase that you thought the American people were concerned about, to what end the programs, these two programs, are being used. And I think that is absolutely the case. I think that was the case when we were debating the Patriot Act and the reauthorization of it, and the concerns that a number of us were raising at that time was, to what end would these programs be used? Congressman Scott has questioned you about some of those ends, and what I want to do is frame this based on the four things that you mentioned in your opening statement. You talked about terrorism, you talked about national security, you talked about cybersecurity, and you talked about criminal activity. In your description of cybersecurity, and you said that that required public-private interaction, and all of these things have become more global, I take it. All four of those categories have become more global. So the question I'm raising is there a distinction between terrorism, the purposes for which information can be used in these programs for terrorism purposes? That's why the statutes were put in place. Is there a distinction between terrorism and national security?
I think terrorism, as defined, is a threat to national security in and of itself. A terrorist act is a threat to...
Does national security include, or does national security include some things outside terrorism?
Include the what?
Some things that are outside the category of terrorism.
Terrorism is a separate category, but you have cyber terrorists, you have individuals, and one of the concerns we have, quite obviously, in the future.
What about trade? Trade is a matter of national security, I take it.
Well, I can tell you I mean, one of the hypotheticals is a terrorist attack, cyber terrorist attack on Wall Street. That is trade. To the extent that you disrupt.
That's trade.
Disrupt that, then absolutely that's a matter of national security.
So I think what you were right, that the public's concern here is, what is the overlap between these four categories, and to what extent can this information that is being gathered be used for things that are in the gray areas here. I was uncomfortable that we got so preoccupied with terrorism that we compromised, I thought, personal liberties, but assume that we got comfortable with that after 9/11. What if you found something in this information that's gathered under these two programs that related more to criminal activity, serious criminal activity? The question is, can that be used? Anything you find in these phone dragnets, can it be used in a criminal investigation if you decide that it's not terrorist related necessarily, but could be national security related or cyber security related? What is the dividing line between the use of these things other than an individual agent's discretion or whatever an individual agent represents in an affidavit to the court.
Let me start by the use of the word dragnet. I do not believe.
I'm sorry.
No, I just want to clarify.
And I didn't intend to use it either. I really apologize. It's data gathering.
It's data gathering.
Yeah.
It is not
okay.
content. The statute is fairly specific that it's attributable to terrorism, and the traditional, what one would understand to be terrorism, Al Qaeda and its like, and other terrorist groups that are specifically mentioned. As I tried to point out before, the program is set up for a very limited purpose in a limited objective, and that is to identify individuals in the United States who are using a telephone for terrorist activities and to draw that network.
Is cyber terrorism? Is cyber terrorism?
Sniper?
Cyber.
Cyber, it can be, but not as distinguished. I'd have to look at that, but I don't believe it would be covered in this particular statute. I tried to leave out the possibility that if there were a piece of evidence that was applicable to a homicide or substantial, the only way for that piece to be utilized would go back to the court and get the approval of the court to utilize this information in a way that was not covered in the original order.
Time of the gentleman has expired. Chair recognizes the gentleman from Alabama, Mr. Backus, for 5 minutes.
Director Mueller, I also want to commend you on your service to our country. And let me ask you, I've been reading about the James Rosen case, the reports on it, and I find a great deal of confusion over what the Justice Department and the FBI have done and what they haven't done. You're familiar with the search warrant and the affidavit?
And that particular case?
Yes.
No, I'm not that familiar with it.
All right. Are you familiar? I mean, at the time the search warrant was issued, Stephen Kim had already been identified as the leaker of the information. Are you aware of that?
I'm not aware of the timing. I know this was 3 years ago.
Yeah.
So
no, actually in 2010, yeah, that's right. He had already been identified. I'll just tell you, if you read the affidavit, clearly he'd been identified as the leaker. And I know that Attorney General Holder said he didn't know of a prosecution, or wasn't a party to a prosecution of the press. And but if you read the search warrant, I know that it talks about Mr. Rosen as being perhaps an aider or abettor or co-conspirator. But if you read the affidavit, he clearly was encouraging Stephen Kim to leak classified information. I mean, there's quite a bit of that. In fact, he was concealing his identity and telling Kim to conceal his identity. Now, also, according to this affidavit, and I take this as being true, I know nothing in this affidavit that has been disproved. This disclosure threatened our national security, clearly, and it probably or could have cost the life of our intelligence source in North Korea. Because I'm not even sure if the person is still alive. Now, just assuming that what I say is that assuming the affidavit's correct and that James Rosen was doing all this information, daily contact with Kim, I know that there's been accusations that the Privacy Protection Act was violated, but it says that the protects journalists from being compelled to turn over to law enforcement any work product or documenting materials, including sources, before the information contained in these materials is disseminated. Now, it was disseminated a year before, so that I don't think is valid. It also prevents investigators from searching newsrooms to uncover information or sources that a news organization has assembled. I don't think that applies in this case. I know of no search of any newsroom or any work product. But it says there's no protection if there's probable cause to believe the person possessing the materials has committed or is committing a crime to which the materials relate to, including receipt, possession, or communication of classified material. Now, this affidavit contains 35 pages of very active recruiting of the State Department employee, advising him, the reporter, to use a fake email. And the search warrant was to Google. So there, you know, it's been said that they should take the government should take reasonable steps to obtain the information through alternative sources or means than the reporter. Well, I would think Google would be an alternative source. And there is a clear presumption, well, there isn't now, but there's a presumption, I think, against seizing reporters' work product. But I would ask you to read that affidavit. And my point is simply, from reading the affidavit, I would think it's clearly within the right of the government to prosecute this reporter.
I can tell you two things. One, I did briefly review the affidavit when the issue arose, so I am somewhat familiar with it. I can tell you that the focus of our investigations are on the person within the government has leaked the information.
Sure.
That is the focus of our investigations. And thirdly, I would say that given the issues that have been raised, that it's appropriate to go back and look at the statute that was applied to that search warrant and to the protocols that have been established in our exercise of our investigative ability when it comes to this tension between the First Amendment on the one hand and stopping leaks on the other hand.
Yeah,
Time of the gentleman has expired.
Chairman, there was no prosecution.
Time of the gentleman has expired. The chair recognizes the gentlewoman from California, Ms. Lofgren, for 5 minutes.